During the so-called tiger boom of the mid-2000s in Ireland, many spouses were asked by their husbands to remortgage the family home for investment purposes. If the spouse wasn't fully informed of the consequences of remortgaging the family home and what might happen if a default occurred, the spouse may have a defense to any claim made by a financial institution called third-party undue influence. The doctrine of third-party undue influence comes into focus when 1. Dependent spouses are unduly influenced into providing their personal guarantee as surety of these loans where the guarantee is fixed to the family home. 2. Contents of the loan and liability pertaining to the loan has not been properly discussed or explained to the dependent spouse. If the loan then becomes impaired because of the debtor's inability to repay the loan, and the creditor seeks discovery and/or repossession of the security to recover the debt, the dependent spouse may have sufficient grounds to have the guarantee set aside. It is necessary to have regard to the equitable remedy of rescission. Undue influence is a basis for rescission and interplay between the doctrine of undue influence and third parties. Rescission is the right of a party to have an agreement set aside and be restored to their pre-contractual position. A loan contract may be rescinded if 1. Validity was affected by the party's wrongful conduct. 2. Undue influence exercised on the innocent party. 3. Transaction deemed to be unconscionable due to the nature of the bargain and circumstances which surrounded its creation. Ulster Bank v. Fitzgerald. Wife claims signature procured by undue influence of husband which bank was aware, should be deemed to be aware. Judge accepted guarantee signed due to inordinate pressure from husband. Judge also accepted bank manager's evidence that each had signed the guarantee in the bank manager's presence, in his office, not present together. Prior to signatures had explained meaning and effect of guarantees, advised the wife to seek legal advice. She signed on the spot. Barclays Bank v. O'Brien. Wife joined in a charge on family home to secure husband's business borrowings. Husband found to have misrepresented to her the effect of the deed. Bank was aware she might be reluctant to sign the deed. Charge not to be enforced. Constructive notice test introduced and set out steps required to be taken by bank to avoid being fixed with constructive notice. Creditor put on inquiry where, on its face, not to the financial advantage of wife. Substantial risk in transactions, that in procuring the wife to act as surety, the husband has committed a legal or an equitable wrong that entitles the wife to set aside transaction. Wife's defense of undue influence failed because she had exercised independence of thought on financial matters when husband away. Successful with misrepresentation. Charge set aside. Bank had constructive notice and failed to take reasonable steps to ensure charge had been obtained without influence, aware of full extent of liability. While society's recognition of the equality of the sexes has led to the rejection of the view that the wife is subservient to the husband in that management of the family finances, it has to be accepted that in many cases it was the husband who had the business experience and the wife was willing to follow his advice. The difficulty the courts had after O'Brien was establishing if bona fide undue influence had transpired. The courts were left second-guessing the quality and abuse that may have existed in each relationship. It was noted in Royal Bank of Scotland v Ettridge that the circumstances in which one person acquires influence over another and the manner in which influence may be exercised vary too widely to permit specific criteria. Ettridge considered the reasonable steps the lender should take. 1. Bank must communicate directly with the wife. Written requirement from her solicitor that she understands the nature of the transaction. 2. Thereafter she should not be able to dispute that she is legally bound. 3. Ask to nominate a solicitor who will advise her, separate from husband. 4. Solicitor may be same solicitor as her husband, however she should be asked if she would rather a separate solicitor. In CIBC v Pitt, principles laid down did not necessarily apply where there was a joint mortgage. Normally benefit both parties, no presumption of undue influence would arise. O'Brien would apply where although for the joint benefit was in fact for husband benefit of wife's benefit was disproportionately small in comparison to potential liability. The fact that the wife had an interest as director, secretary, shareholder would not relieve the bank of obligation to inquire. Boy v. Smith. Bank's claim for possession of family home dismissed by the HC. No valid consent by the wife as required by the Family Home Protection Act 1976. Although had signed consent, did not understand nature of transaction. Ulster Bank v Roche and Buttimer. Buttimer entitled to rely on undue influence which Roche exercised over her as a defense to Bank's claim. Failure of Bank to take any steps to ensure she was acting freely in circumstances where Bank had been placed on inquiry. BCCI vs Al-Budi. She was 20 years younger than husband, married when 17. Had signed documents relating to husband's business for many years without reading or questioning them. On the occasion which gave rise to litigation, she had signed a number of guarantees relating to the matrimonial home. Bank's solicitor had one meeting and attempted to encourage her to take independent legal advice. During the meeting, Mr. Al-Budi came into room and reduced wife to tears. Held he had unduly influenced wife and concealed relevant matters in a bullying manner. Led her to sign for want of peace. Following dicta in National Westminster Bank plc vs Morgan, held claim could not be set aside. Was not to her manifest disadvantage. Risks did not outweigh benefits. Ettridge guidelines should be relied on pending further authoritative decisions from courts.